It's a great privilege for me to be able to join you this morning. As you've heard Catherine say, I've been on the bench for just under 2 years now and began working with the Mental Health Treatment Court immediately upon taking the bench last February. The rest of my docket is a criminal misdemeanor docket and the traffic docket. So everything that I do involves working with people who are involved in the criminal part of the justice system. What I learned as I took the bench is that judges in Michigan had become concerned about what they observed as the revolving door concept in our criminal justice system. People would offend. If they were found guilty, they would go to jail. They would serve their jail time. They would be released. And if they had an underlying concern, health issue, mental health issue that was triggering their criminal behavior, it wasn't treated. And so within a few months, we would often find the same people committing similar offenses, again being sentenced to jail, serving their time in jail, again being released, and this revolving door was just continuing. People became very concerned about it, and the Michigan Supreme Court approved the use of specialty problem-solving courts or treatment courts in Michigan to start to address this concern. The mental health treatment courts were established by the state legislature in May of 2013. So they're still relatively new in the state of Michigan. And our court is funded through a state court administrative office grant. And what I've learned from speaking with the people in this court is that it costs the taxpayers approximately $35,000 a year to house a person in jail in Michigan. If a person comes through the mental health treatment court, I have about $6,700 a year to work with that person and successfully help treat the underlying concerns which may have triggered the criminal behavior and prevent them from being incarcerated for long periods of time. We are just entering the 4th year of the Washtenaw County Mental Health Treatment Court, and we meet every Wednesday at 1:30 at the 15th District Court in downtown Ann Arbor. But as Catherine said, any defendant in the county who qualifies for treatment through the Mental Health Treatment Court can be assigned to our court for their probation. So the reason that we are so firmly committed to working in this court is because we want to offer individuals who are involved in the criminal justice system and who are also struggling with severe and persistent mental illness and oftentimes co-occurring mental illness and substance use disorders, to have access to a community-based, recovery-oriented alternative to incarceration. As everyone in this room is aware, people who are suffering from untreated mental illness can be the most marginalized persons in our community. They struggle to find resources for treatment and often are not capable of managing to find those resources on their own. Many of our participants come to the court with stable family situations, family support, although their families may not always know the best way to assist them, and they're housed. Probably more often, our participants are homeless and unemployed. We find that their sole source of income may be Social Security, and their health care is often provided through Medicaid, and they are not able to successfully access resources on their own. Sheriff Clayton has informed us that approximately 50% of the Washtenaw County jail population suffers from some form of mental illness. I took a course in Lansing from a national organization about the crisis of mental health treatment in our country, and they informed us that the largest provider of mental health treatment in our country right now is the Cook County Jail, where most of the mental health treatment that is provided there happens in the jail to the extent they have the resources to provide it, and over 5,000 of their inmates are diagnosed as mentally ill. Our law enforcement partners are reporting, particularly in the last several months over this past summer, that they are having increasing contact with the same numbers of persons on our streets in Ann Arbor over and over again. And so they're become very active partners with the Mental Health Treatment Court to try to avoid incarcerating people, but to help people get the services they need so they can avoid committing more crimes and avoid incarceration again. I'll just note that this is this specialty courts are a trend throughout the state of Michigan, and in Ann Arbor, besides the mental health treatment court, I also preside over the Veterans Treatment Court. Judge Burke presides over the sobriety court for persons who are struggling with alcohol addiction, and Judge Hines presides over a special domestic violence docket and a street outreach court. Judge Pope in Ypsilanti Township has a drug treatment court and a court that specializes in helping women who've been traumatized and victimized. So in Washtenaw County, the judges are dedicated to working with people who are vulnerable and trying to find healthy solutions for people so they can return to becoming productive members of our community. I think the best way to help you understand what a person would experience in our criminal justice system is to first go through an average scenario for a defendant who's charged with a crime and who does not enter a treatment court. And then I'll take you through that same person's journey if they come into the mental health treatment court to have their probation supervised. So my imaginary participant is a young woman who is suffering from incapacitating anxiety and depression. It's not being treated. So she's self-medicating with the regular use of alcohol and marijuana, and she's occasionally using cocaine when she can get her hands on it. She had a supportive family environment, but her family's not educated about how to work with mental health and substance abuse issues. Their patience has become exhausted, and they have asked her to move out of their home. They have not found a way to successfully help her cope with these issues. She's currently traveling from friend to friend's home or extended family member's home and residing with them as long as she can until they ask her to leave. But of course, she has no job and she has no income, so when she's living with her family and friends, they're supporting her. As she becomes increasingly desperate for money, she finds herself walking down Main Street in Ann Arbor and notices a person walking in front of her with a backpack that's slightly unzipped, and his wallet is sticking out of it. So she impulsively reaches in, grabs the wallet, opens it, finds that she's hit the jackpot. This person's carrying $250 in cash. As she turns to leave, the person realizes what's happened, grabs her arm, and calls the police. So she is arrested with the wallet in her hand and the money in her hand. She doesn't have much of a defense to the fact that she didn't commit the crime. So she will be appointed an attorney to represent her in this criminal case at the court's expense, but she is found guilty of this crime, which carries a maximum penalty of a year in jail, a $2,000 fine, or 3 times the value of the property that was stolen. She will meet with a probation officer who will make a recommendation to the judge about what her sentence should be. And a typical sentence for this type of a crime would be that she would serve between 6 and 12 months on probation. She would pay fines and costs. She would be asked to do community service, and she would be ordered not to use any alcohol or illegal drugs. She has to meet with her probation officer once a month. She still doesn't have a job. She still has no income. Her mental illness is still not treated, and she's still homeless. So her likelihood of being able to pay the fines and costs is quite low. She may be able to find a way to start doing the community service, but she's still going to use alcohol and drugs. So eventually she violates probation. She comes to see the judge again after the probation officer reports that, and the judge may give her a warning for this first violation and remind her that she's not to use alcohol or drugs, may order her to complete additional community service as a sanction for violating her probation. It's only a matter of time before she violates probation again, and the probation officer learns that she's still using alcohol or drugs. She's back in front of the judge. This is her second violation. It's not unexpected for the judge to then sentence her to serve the rest of her time under her original sentence in jail and unsuccessfully discharge her from probation. So there's no more oversight of this person once she finishes serving her time in jail. The treatment courts operate in a cooperative, team-centered manner, and we try to create and assist a court participant in completing their sentence supervised by probation with an individualized treatment plan so the person can develop and maintain the coping skills needed to stabilize mental health, stop using illegal substances, be housed, and learn coping skills to live life after the court involvement in a productive and healthy manner. So if this same defendant who just committed the same offense under the same circumstances comes to the attention of the mental health treatment court, the first thing that would happen is she would meet with our probation officer, who just walked in. So I want to say hello to Pat Chase. He's here in the back of the room. And Pat is the person who our court participant is going to have most interaction with at the beginning of their time with the court. So if this young woman's defense attorney or the prosecuting attorney or the judge who was overseeing her case realized that she had mental health concerns, or she herself reported that she had mental health concerns, there's a mechanism where anyone in the county can refer that person to our treatment court. Our court coordinator, who works for us 29 hours a week and keeps us all organized and keeps all the paperwork in place, will meet with this young woman, get her practical background information, and then we'll make sure she has an appointment with our probation officer. As the case progresses, or I should say as the evaluation progresses, we're concerned that the participants who are coming into our court understand they're making a commitment to do a lot of work. They have to decide whether they're ready to begin working on the underlying issues which are causing problems for them. You heard before they would have, in the normal system, they would have a monthly meeting with their probation officer, and they would never see the judge after the initial sentencing unless they violated. In the treatment court, they're going to see our probation officer once a week for many months. They're going to come and see me in court every other Wednesday for several months, and but they are going to be put in contact with treatment providers who they will also have to meet with. So the other thing that happens is the members of the court's treatment team meet regularly to talk about all of our participants and make sure that we understand what their needs are and that we understand their treatment plan and whether it's being effective. So our defense attorney meets with every participant, and our probation officer and our defense attorney explain to the person what the program is all about, what their commitment is, and that they sign a release of information which allows us to have access to their treatment plan and to discuss it confidentially within our group as they're moving through probation. So anyone who comes into our court as a defendant is coming in voluntarily. No one is ordered to participate in this plan. The next thing we do is connect each part. So once the decision is made that a person qualifies for our court because the type of crime is nonviolent and they have a chronic mental illness which has triggered their criminal behavior, they're connected as soon as possible with treatment. Our goal is to have someone connected to treatment within 14 days of being assessed. And the treatment provider develops a treatment plan which is individually tailored for each participant. That plan becomes the probation sentence that they're serving. And so we both monitor the plan to see if it's effective and hold the person accountable to comply with the treatment plan that's been developed. And the plan is developed with the mental health care provider, our probation officer, and the participant herself who is going to explain goals, immediate goals and maybe distance goals as time is going on through the period that a person is on probation with us. Their plan may include medication reviews, individual or group therapy, psychiatric evaluation and counseling, substance abuse treatment if there's a co-occurring disorder, case management, housing assistance, free bus passes, life skills coaching, peer recovery coaching, education and job skills training, and we are now developing supportive employment. So we have employers in the community who are willing to offer employment to people who need a little extra support while they're developing job skills, and learning how to perform their job. So that is something that we're in the process of developing right now. The plans are tailored to promote public safety, so we don't lose sight of the fact that people need to stop committing crimes. We facilitate the participants' engagement in their treatment, and the goal is to provide a positive legal outcome for any participant in the court who successfully completes the treatment plan. The court treatment team meets for 2 hours every Wednesday before our docket to make sure we understand what's happening with each participant, that their plan is effective, if they're struggling, whether the struggle is because they need additional assistance or a different type of plan, a different type of support, or whether it's willful, in which case we'll talk about their responsibilities in the courtroom during the docket. As I said, we have a court coordinator who runs our day-to-day operations and manages all our paperwork and our grant compliance. Our probation officer has a master's in social work, and he really is the heart of each person who's on probation, contact with the court and fulfillment of their obligations, but also he's often the first point of reference for when things aren't working for a participant. So people will meet with probation officer once a week for the first couple months of the time that they're with us on probation, which could be 12 to 24 months, and then gradually decrease to every other week. We have an assistant prosecuting attorney from the Washtenaw County Prosecuting Attorney's Office on our team. She helps us make sure people are not reoffending, or informs us if someone has reoffended so we can begin working with them right away, and make sure that we remain compliant with the agreements we've made with the prosecutor's office to hold people accountable. We also have a defense attorney on our team, and she attends every team meeting and every docket and is available to every person in the court to advocate for them. She advocates for them during the team meetings. She advocates for them in court. And if a person has done something significant enough to violate the probation agreement that they have with our court, she advocates for them during the violation probation hearing. We have a social worker from Community Mental Health who's our court liaison, and he provides the initial psychosocial assessment for each person who's entering the court, provides the diagnosis, helps develop the treatment plan, and is our contact with Community Mental Health to actually help our people schedule their appointments, manage their appointments, keep track of their appointments often, and will make recommendations when the time comes to revise someone's treatment plan, either to move to a different type of group treatment or reduce the obligations that have been placed on a person if they're feeling overwhelmed. We also have a social worker from Home of New Vision who's a part of our treatment team. She's a court liaison from Home of New Vision, and when someone has a co-occurring mental health and substance use disorder, we often work with the professionals at Home of New Vision to manage the substance use recovery, and they have the skill and the understanding to take the mental health issue into consideration. And it's often a balancing act to decide whether the mental health issue is primary or the substance use issue is primary. And so they have a lot of different services available for our participants, which can include short-term residential placement when someone needs time to become stabilized before they can continue living in the community. Recently, one of the treatment coordinators from Dawn Farm joined our team and is coming to every team meeting. And when we discover that the substance abuse is the primary problem that needs to be addressed before the mental health treatment can be effective, and we learn that the person has struggled and needs a longer-term residential placement, we are able to have our participants go to Dawn Farm for their 90-day residential treatment program. They develop an aftercare program before they leave Dawn Farm and move into transitional housing, usually for 6 months. So they move from the residential program at Dawn Farm into transitional housing where they live with other persons who are committed to maintaining their sobriety. In the meantime, we are still helping them stay in contact with the mental health treatment that they need. And so Dawn Farm is supportive of that as well, although they don't provide the mental health treatment. We have added a social worker from Avalon to our treatment team over the last several months. And what we found was, while all of our partners on the team were very good at providing the services they had agreed to provide and were able to provide, there's a certain level of care that certain persons need that no one was providing. Things, we would just say, well, here's a bus pass, you can get to your therapist appointment, you can get to your group meetings, just use the bus. And then we'd find the person wasn't complying with going to the meetings, and we would have more of a conversation and find out they didn't know how to use the bus, or they were afraid to use the bus. And so we have a social worker from Avalon who's working with us 20 hours a week now. And for those types of very basic life skills that a person may not be prepared to handle, he will work with the person until they learn how to ride the bus. He'll ride the bus with them until they become familiar with the route. He will help them go and apply for their ID cards. He will make sure they have a phone that works so that we can all stay in contact with each other. We have some people who are quite severely ill and really can't keep track of what they need to do, and we discovered over time that they weren't being obstinate about complying with the treatment plan or coming to meetings or coming to court. They simply couldn't keep track of it on their own. So he sets up alerts on their phones, he sets up an alert on his phone. The alerts serve to remind them that they're supposed to come to court or come to their probation meeting or go to treatment, and then he calls them to make sure they got the alert. So a pretty intense safety net for people while they're stabilizing enough to be able to manage these day-to-day behaviors on their own. He works with people on budgets, he works with people who need to apply for assistance, and he works with people who are homeless and make sure that they are on the appropriate list to find affordable housing. And we also were recently joined within the last 2 months by the treatment provider from the Washtenaw County Shelter Association. She actually called us and said, I want to be part of your team. And I was thrilled that we had more people in the community reaching out to want to work with us. But I didn't think we had anybody that was living in the shelter in our court. And so I was confused about what she could offer us. And I've learned that the shelter has non-residential services. So even if a person is not living in the shelter, they have programs going on all day. And she said, trust me, I have people from your court who are at the shelter quite a bit, even though they're not living here. And so she's joined our team, and she can connect people to job skills training, different types of medical care if they're not already provided by one of the other providers because of insurance complications. She connects them with the Packard Health Center for psychiatric treatment. She has a place where they can shower if they're still homeless, and she's been a great addition to our team. We have police officers from the city of Ann Arbor who sit on our treatment team. There's a small group of officers who are trained in community engagement and who are committed to diffusing situations on the street, de-escalating problems before they rise to the level where someone's going to be charged with a crime. And they will bring people to our attention and help they know our participants, and they help our participants if they see them getting into a situation where they just need to be disentangled and helped to get to an appropriate service provider as opposed to escalating into actually committing a crime. We do use the Fresh Start Clubhouse quite extensively and wish there were, I was just talking to them about the fact that we wish there were 3 or 4 Fresh Start Clubhouses in the county. Our court participants are often alienated. They don't have what they consider strong family support or a strong network of healthy friends. And they love, the people who go to Fresh Start Clubhouse love going to Fresh Start Clubhouse. That's their place, and it's safe, and they can perform community service there, but they can also socialize in a safe place. And a couple of them have said to me, you need to talk to them about getting more Fresh Start Clubhouses because we really like it, but we don't want it to get too big. We like this small, community where we know everybody. And so that fact that we have Fresh Start in Washtenaw County is a great benefit. And then I would be remiss if I didn't give strong accolades to NAMI. NAMI has been involved in this court from the beginning. I see many people here who have been volunteers in the court. There are NAMI volunteers who come to the court every Wednesday and sit through our docket with us. They sit with the participants in the court. They listen to what people are saying and what people need. They make individual personal contact with our court participants. They start to learn what people need, and they quietly provide that extra level of support that a person needs to either get through the court hearing or the day or the unexpected incident that may happen in court. They provide a lot of just day-to-day contact, as I'm sure all of you know that are here. NAMI volunteers are wonderful. Also, Pat and the rest of the team provide the peer-to-peer program for our court participants at least once a year, although now that we have a little bit bigger grant this year, we're hoping to increase the numbers, depending on the volunteers' availability, the numbers of times we're able to offer the peer-to-peer program to our court participants. Often court participants' family members are in court, and Pat and the rest of the volunteers, Catherine, make contact with the family members of our participants who are in court and talk to them about learning how a family can support a person who's in our court and who needs continuing assistance after they're finished with our court. So it's wonderful to have people from NAMI as partners with our court, and it's been very beneficial and very effective. So to go back to our imaginary defendant, she's been through the screening process. It's been found that she's eligible for participation in our court. She has been for her psychological assessment, she's been for her substance abuse assessment, and she's started to develop a treatment plan with the probation officer and the treatment providers. She comes to court and sees me every other Wednesday. We have court every Wednesday, but people come every other week at the beginning of the time that they're on probation with the court. And so there are usually about 15 to 20 people, other participants in the court, and each person is called to the podium one at a time, and we talk about what's happening with their treatment plan. We're careful not to divulge confidential information that a person may not want divulged, but we talk in general terms about how things are going for them, what needs they have, what they're succeeding at, what their extra challenges are, what extra help they think they may need. Anybody who is compliant is congratulated, applauded, usually by the rest of the members sitting in the court as affirmation. A person who is doing particularly well with their program week after week will move to the point where they have to come to court only once a month and have to meet with their probation officer twice a month instead of every week. And other affirmations are that any person who's been compliant with their probation requirements since the last time I saw them in court is called a star of the docket. We have a whiteboard in the front of the courtroom, and their name is on the board as a star of the docket. They're called first during the court proceedings as an additional reward for doing so well, and then their names are placed in a drawing. Once we've spoken with everyone who's a star of the docket, there's a drawing for a $25 gift card. So every time we're in court, someone wins a $25 gift card, which could be a gas station card, a movie pass, food, a local store, and they choose whichever one of the cards is most important and appropriate to them. Sometimes we have people who aren't compliant with their probation requirements or significantly non-compliant. And we talk about that and why they're not compliant and the fact that this is still a court and they are still being held accountable for having committed a crime, so they will be receiving sanctions for their non-compliance. Early in the program, a typical sanction will be I'll ask the person to complete a writing assignment telling me why they chose to be in this court, what they hope to gain from being in the court, what their goals are, and anything else they want to share with me. Sometimes people think that's kind of a pretend sanction. I've gotten feedback from members of the general public that that's just, you're not really doing anything. I have been continually amazed at the level of insight people bring after they've done that writing assignment. They clarify for themselves what their struggle is, what their goal is, what they need, what they're not getting, what their part in the non-compliance is. It's really a very powerful tool, especially for people who are just starting out with the court. If they have been allowed to reduce their meetings with the probation officer, we will increase them again until a person's able to maintain compliance. I'll ask them to come to court more often as another sanction, until they're able to maintain compliance. And we often require people to do community service as a way of recognizing that they didn't comply with the program, but also that part of our program is people reintegrating into the wider community and being of service to others. So that's a common sanction, different levels of hours of community service. When a person is continually non-compliant and it becomes clear that it's intentional, as a last resort, I will sentence people to jail for short periods of time. I would very rarely discontinue their probation, but sometimes jail serves as a wake-up call, and a couple days in jail will help them have time to sit and think and refocus their commitment to the court. So after a person has successfully completed between 12 and 24 months of probation, they've accomplished their goals, they've completed their treatment plan, they're stable, their mental health is stable, they're eligible to graduate. And so in a traditional court, when a person has finished their probation successfully, their probation officer will tell them, you've successfully completed your probation, everything's fine, I'll sign an order and it'll be mailed to them, and that's it, they're off probation. In our court, when someone has successfully completed probation, we have a graduation ceremony. And different members of the team will congratulate the person for the accomplishments that they've achieved. Often, the participant will share with the other members of the court what they gained or what they liked about the court. They will often tell people that at the beginning they really hated me, they really hated the court, they really were kicking themselves for having signed up to do this much work. So people are really honest, but invariably if they're graduating, the next sentence is their gratitude for the fact that they had the opportunity to participate in this court and receive support to become healthy. And we have desserts, and we have a certificate that they receive. Everybody on the team signs a congratulation card for them, and they receive a gift card as their final gift from the court on graduation. Our challenge, of course, is always to find enough resources to meet our participants' needs. As most of you are aware, in Washtenaw County, affordable housing is always difficult to come by. So we're constantly scouring for affordable housing for our persons who come to us are homeless. But one of our primary goals when someone comes to the court and is homeless is to have them be housed. It's very difficult for a person to start dealing with serious mental health issues and substance abuse issues if they are spending most of their time looking for the place they're going to sleep that night. All of our graduates have been housed all of our participants have been housed so far by the time that they graduate. So that's a tribute to the members of this community who are so generous in working with people. It's encouraging to know that the Michigan Supreme Court is committed to problem-solving courts and continuing to fund problem-solving courts. We now have 33 mental health treatment courts in the state. Of course, it's important to evaluate the effectiveness of these programs. And the last report I had from the Supreme Court evaluating the statistics showed that they were looking at whether a person improved their employment or their educational status while they were with the court, whether their mental health improved, and whether they had improvement in the quality of their life. In our court over the last year, we've averaged 45 participants throughout the year. They range in age from 18 to their 70s. They're people of all races, all ethnic backgrounds, different genders, and yet after they've been with the court for a while, they coalesce and support and serve each other as they're going through the process. What the Supreme Court found as a result of their evaluation is that statewide, 49% of the people who participate in the mental health treatment courts successfully complete the program. Of those, 27% had improved their level of education by the time they graduated. 43% had improved their employment upon graduation. 99% reported improved mental health. 97% reported improved quality of life. And 92% were compliant with their psychotropic medication use. And this is a huge step forward for the people that have been participants in our court. Of course, this is a criminal justice system, so we're also interested in whether these efforts are helping people with the recidivism rate. And the Supreme Court defined recidivism as any new conviction in the area of substance use or possession, manufacturing or distribution, driving under the influence of alcohol or drugs, any other alcohol offense, a property offense, a breaking and entering home invasion, other nonviolent offenses, money crimes, weapon offenses, or fraud. And they found that 2 years after a person's admission to the mental health treatment court, 50% of the people who had successfully completed their time in the mental health treatment court, fewer committed crimes than persons who'd been convicted of similar crimes, gone through traditional probation or jail and not received treatment. So it's a 50% reduction in recidivism. Now those statistics are 2 years old. Mental health treatment courts just came into being in Michigan in 2013, so I'm looking forward to the updated statistics now that we'll have almost 4 years of information to look at. And so I appreciate your attention, and I want to leave time for people who may have questions to ask those questions. Does anybody? Right now, we have the NAMI team and the NAMI program, and I think that's an excellent suggestion, and it's something that our team should look at. Right now, we rely on the NAMI program, but some family members are committed to working with their loved ones, and it would be helpful if we could offer them either connection to the treatment team with their loved one, but of course then we'd have to get permission from the participant because these are all adults. But I think that's a question that we should explore further. Thank you for bringing that up. We do not have organized follow-up meetings because once a person's completed probation, I have no authority to order them to do anything. They're out from under the jurisdiction of the court. Many, I shouldn't say many, some choose to stay connected to their probation officer or other people in the court who've supported them. But before a person graduates, we have them develop their aftercare plan. It's written. It's one of the things they may present at graduation if they're comfortable sharing that information in public. Otherwise, it's given to the probation officer, and they will maintain contact with all their treatment providers. And so they can continue to receive services that way. I do have people drop in from time to time to say hello and let me know they're doing okay. They don't always come on Wednesday afternoons. Sometimes people on my regular docket are quite startled to have people pop into court and just say, hey, I just want you to know I'm doing fine. Yeah, in fact, yesterday I had a sentencing docket, and one of the people who did not go through my mental health treatment court, but I used mental health treatment court strategies on his probation, but he was a drug user and he ended up in jail. He came over from the jail. He has to be transported over to tell me that I had saved his life, and he was grateful that I'd been tough, even though he really was wanting to throw things at me originally. So it's not formal contact, but the way we know if someone's committed a crime is that's public information. That's one of the things that the person, him or herself, the defense attorney and the prosecuting attorney have to work out. In the regular court, that's often part of a person's sentence. So successful completion of a sentence can result in dismissal of the criminal charges and no conviction. And people in our court can ask for that or negotiate for that or go back and ask for that after successful completion in the court, but it's not something that we guarantee will ever happen for anybody. If a person is exhibiting signs of mental illness, and most of the professionals in our county now are very alert and have been educated about what that might look like, The prosecutors know, the defense attorneys know, the judges know, the police officers know. But if it's a family member who's in court or knows that their person's been arrested, their loved one's been arrested, certainly that person can make a referral. And then part of the screening process for admission to the court is for the person to have a formal evaluation. And if they're diagnosed with a continuing mental illness, and if the crime is a nonviolent crime, meaning not murder, not kidnapping, not anything that resulted in a serious bodily injury to another person, we can accept them into the court if they plead guilty or have been found guilty. So it is based on a crime being part of the behavior. No, the person's participation in the mental health treatment court is confidential. It does not go in the public record. Any person who's involved in any treatment court, the fact that they're in a treatment court is not part of the public record, although the doors to the courtroom are open during our review dockets. We did take some people in that situation occasionally, and we found that we were not able to offer particularly effective treatment because they weren't capable of traveling to Washtenaw County once a week for a probation appointment, every other week for a court appointment, 2 or 3 times a week for a psychiatrist appointment, a therapy appointment, a group appointment, or a substance use treatment. So right now, and we have a waiting list for people who would like to come into our court. So right now, when we find someone in that situation, we try to find a treatment court for them that's located closer to where they live, and then I will call the judge from that treatment court and let them know that the only reason we're not taking them is the geographic difficulty with having the person come here. Yeah, so during the evaluation with Mr. Chase, that would have to be made clear so that if that's an exception and the person can actually come and receive the benefit, we're happy to work with somebody. They can make an application to serve out the rest of their sentence in the mental health treatment court under our supervision. That's a little more difficult depending on what kind of crime they committed, but anybody who's already serving a regular probation with another judge or another court, and during that time they reach the realization that their mental health is what's driving their criminal behavior, or they already knew that but they didn't really want to sign up for as much work as we were doing, and they become ready to sign up for doing that much work, most of the judges in Washtenaw County will assign them to our court and allow the transfer. Well, we can't impose it on anybody. I can't order any. It's voluntary because their personal information, they have to sign a release of information about personal medical information. So when someone's having a difficult time deciding if this is for them, I invite them to come and sit in on a court docket for 2 or 3 weeks and see what happens in court. See if they think it would be beneficial to them. They meet with our probation officer. He talks to them about it. They have the opportunity to meet with the defense attorney if they're concerned about it. And sometimes they'll decide to give it a try and then they'll regret that they decided to give it a try. But one of the things we're very aware of is that too many requirements can be detrimental to people. They can be overwhelmed. That can be counterproductive. And that's why each plan is very carefully tailored. So she may not be doing 4 or 5 or 6 meetings a week because she's already employed. And so we'll tailor it to help her meet her goals. And maybe her first goal is just to deal with her anger. And so we'll ignore everything else that's happening with her until she's had enough time to successfully complete that goal, and then we'll add another layer. since the courts have been started, they have been doing annual grants. So they're very careful to review what we have to do, very, very detailed reports, not using our participants' names, but using information about who's compliant, have they committed another crime while they're with us, do they come to the meetings, do they come to court, do they meet with their probation officer. Quite a comprehensive report, and we have to reapply for the grant every year. This process is a real deviation from traditional judicial behavior, and so what the courts have realized now after a few years is they want to have us certify that we're meeting certain requirements, confidentiality requirements, and all the rest of the things that I described. And so we were just awarded a grant for 12 months, but when we apply next spring, we will also be being reviewed for certification, and we have all the guidelines that we have to meet for certification, and then we'll receive a 4-year grant. And then the cycle will be every 4 years, and I'm thrilled that the court is really allowing us to be certified and giving us specific benchmarks so that it's really a protection for the people who are participating in the court. Once a person's graduated, I don't have any authority over that person anymore. They've completed their probation, they're released from probation, they paid their debt to society for the crime, and we can't go back and say, you know, you're doing something else. So if it's a loved one or someone that a neighbor that you're close to, you may have to find other ways to provide supportive intervention, but you can't come back to the court at that point. Yes, because part of the certification is that people who are agreeing to participate in our court actually receive the services that they're signing up for. And we have one probation officer, and he works 40 hours a week. And so the state mandated caseload is 45 people at a time, at any one time. And so as people graduate, of course, we immediately let everybody in the legal community know we have room for more people. Probably 5 or 6 right now. But we're graduating people, and we're having a couple other people move on. So it's not a lot, people aren't waiting for a long time. I'm not keeping track of where they are, but they're probably at least on probation with a traditional probation officer. Thank you again for all your attention. I appreciate it.